Good afternoon and welcome to today's BCLT Advanced Life Sciences Institute session, where we're going to be exploring the nuances of written description under Section 112 with an expert in this space, Kiley White. Kiley is an associate at the Tensegrity Law Group. She has extensive experience in patent litigation matters in U.S. district courts and at the U.S. Court of Appeals for the Federal Circuit. She has experience both plaintiff and defense side, and her practice includes a wide range of technologies, including biotherapeutics, pharmaceuticals, and semiconductors. In addition to her substantive legal practice, Kiley is very active in the community and in several bar associations, including leadership in the Giles Rich of Court and the intellectual property section of the American Bar Association. Before joining Tensegrity in 2020, she served as a law clerk to the Honorable Polly Newman of the U.S. Court of Appeals for the Federal Circuit. I've had the pleasure of discussing these issues with Kiley on many occasions, and I'm really thrilled that you all are going to get the ability to benefit from her expertise. And so with that, I'm going to turn things over to her.
All right, thank you, Allie. I will begin with the general disclaimer saying that today, anything that I say are solely the views of myself and are not attributable to my firm or to any of my clients. Okay, so 112 in written description. So today we will be talking about the written description requirement of Section 112 and some recent developments from cases over the past year or two. And in reviewing those cases, it was apparent to me that there were at least what I will call two overarching themes that are somewhat intertwined together. So the first theme is related to the state of the art, or in other words, what information was already known in the art, and along with that, how much and when you can rely on the state of the art for meeting the written description requirement. The second theme is related to the use of expert testimony. Now, I said that they're interrelated, and that's because the use of expert testimony includes relying on your expert to explain what was already known in the art. But her testimony isn't limited to just the art. Instead, her testimony can also be used to show how a POSA would understand specific terms in the specification. Can also be used to explain whether there were any inherent limits in the art, and if so, what those limits were, and whether the specification meets them. And another example would be to use her testimony to explain the interrelatedness or lack thereof between different embodiments in the specification, and whether a POSA would understand that there was a complete invention described, or maybe it was just an obvious invention. And we'll discuss this all in further detail in the next 45 minutes or an hour, and I'll give you an overview of the most recent cases, including some key takeaways. But before I do that, I want to set the stage. So we're going to go over some common issues that you're likely to encounter, including those addressed in recent cases. So let's start off with some basics. Why is there a written description requirement? So the written description requirement is a statutory requirement. It's in 35 U.S.C. Section 112. And Section 112 provides that the specification shall contain a written description of the invention and of the manner and process of making and using it in such full, clear, concise, and exact terms as to enable any person skilled in the art to which it pertains or with which it most nearly connected, etc. So the part that I have highlighted here, that is the actual statutory written description requirement. But what does it mean? So the test for written description, as articulated in Ariad, is the test for sufficiency. The test for sufficiency is whether the disclosure of the application relied upon reasonably conveys to those skilled in the art that the inventor had possession of the claimed subject matter as of the filing date. So by possession, they mean its possession as shown in the disclosure, or in other words, what's shown in the specification. And another articulation that you'll see is that the specification should show that the inventor actually invented the claimed invention. And you'll see both phrasings today are used by the court. But we'll be spending a lot of time today discussing the part that's in green. So What I highlighted here is that the test is from the perspective of a person of ordinary skill in the art. So let's dig a little bit deeper as to what it means to be from the perspective of one skilled in the art. So in Lizard Tech, they explain that your skilled artisan has a certain amount of knowledge, and when reading the patent is allowed to use that knowledge to understand the specification. So you don't need to spell out every detail of the invention. At some point, it'd become a treatise if you had to explain every concept, and then every concept subsumed within that one, et cetera. And really, that's not part of the quid pro quo of the patent bargain. And this is further articulated in Zoltec that part of the requirement is to make sure that the public receives sufficient knowledge of the patented technology. So if it's already in the prior art, broadly speaking, then you don't need to provide it because it doesn't provide anything new. So as Zoltec states, the written description need not include information that is already known and available to the experienced public. So taking this all together, what do you need to include to show you actually invented the invention and you have possession of it? Can you really omit what's already known in the art entirely? And the answer to that is no. So you'll see that you still need to include some statement showing that the subject matter is part of the invention. What does change, though, is how much you need to explain, which will depend on what the actual technology is. And this is where an expert can be really helpful. But yeah, overall, you'll see that the cases will show that you cannot simply omit the subject matter altogether, even if it's known in the art already. So I've broken it down into different buckets of types of cases, where I think taken as a whole, the groups of cases will show how these issues really play out in the courts and how they can best position you to defend whichever side of the V you're on. So first, we're going to start off with cases where it's going to be fairly challenging to rely on the state of the art. So the first group of cases is when there's a broad claim and the claims are silent as to the disputed claim scope. And either the silent scope would replace a feature that is really critical or essential to the claimed invention, such that if you replaced it, the invention wouldn't work anymore. And the second area is if the scope was in the prior art and the invention discusses the advantages, the disadvantages of the prior art and the inventions distinguished from the prior art. These two areas, you're going to have a very hard time using the state of the art to your advantage. So let's go over some specific examples to make this a little bit more concrete. So the first case, it's pretty old. This is Gentry Gallery, but it still appears in a lot of case law because the principle is still applicable. So this is a case about sofa recliners and the positioning of the recliner controls. In the district court, the patents were found to be not infringed and not invalid. Gentry appealed the non-infringement and Berkeley cross-appealed the no invalidity determination. And the issue here is whether there's written description for controls located in a place other than on a console. So claim one, you see, is directed to a sectional sofa that includes a fixed console and a pair of control means, one for each reclining seat mounted on the double reclining seat sofa section. And then there are dependent claims that further specify that that are directed to a sectional sofa in which the control means are specifically located on the console. So the question is, for claim one, which is presumably broader, is there written description support for controls located not on the console? Okay, so is there written description support for controls that are not located on the console? And the answer here is going to be no. So the Federal Circuit, they didn't just rely on the fact that every disclosure has the controls on the console. Really, they looked at the overall invention, including the problem to be solved, where previously, because recliners had to have adjustment controls on their arms, sofas were only able to contain two recliners if they were at the end of the sofa. And because many sofas are L-shaped, that means the two recliners would be facing different directions. And it didn't really work out. There are other problems associated with it, but their solution was to place a console between two recliners, which face in the same direction. So as the specification states, the console accommodates the controls for both reclining seats. Okay, so the solution was to place a console between the two recliners facing the same direction. So the console would accommodate the controls for both reclining seats and thus eliminating the need to position each recliner at an exposed end of a linear section. So here, basically it hinged on that one skilled in the art would clearly understand that it was not only important, but essential to Sproul's invention for the controls to be on the console, right? This was the entire purpose of the invention. So to put them elsewhere would really be contrary to the overall purpose of the invention. So here there was not written description support. Okay, next is ICU medical. So ICU medical is about valves that are used in medical IV setups. Here, prior techniques involved using needles that had certain problems. And the solution was to use a medical valve that received fluid from a syringe without the use of a needle. And the issue was whether there was written description support for a valve without a spike. So you'll see here that claim 9 is directed to a valve that specifically requires a spike. So some of the claims do require a spike. But then we won't go into all the language in claim 35, but claim 35, for example, is silent as to whether the valve requires a spike or can be spikeless. So here where the issue is whether or not there was a written description for a valve without a spike. Again, the answer is going to be no. But also, just like Gentry Gallery, the decision didn't only revolve around the fact that there were only embodiments that had valves with spikes. That wasn't just the limit of the court's determination. Here, the court found that the spike was essential for the invention to work. The specification had repeatedly stated that the purpose of the spike was for piercing a seal inside the valve and that the piercing was required for fluid transmission for the invention to work. So if there wasn't a spike, then the invention overall would not work. So there was no written description support for spikeless valves. And here I'll just note that they attempted to argue that a spike was not necessary for piercing based on one disclosure that included a pre-slit seal. But this ended up being insufficient, even though they relied on some expert testimony. But all the disclosure showed was that the pre-slit seal facilitated the invention, but it didn't actually remove the requirement for a spike piercing the seal. It really just made it easier. So overall, it might have been an obvious invention, but there is not sufficient written description. Okay, distinguishing the prior art. Okay, Tronzo case. So Tronzo is about an artificial hip socket, where here the issue is whether there's written description support for claims that are silent as to the shape of the cup or any claim that does not require the shape of the cup to be conical or trapezoidal. You'll see here in claim 1 that the cup does not have a specific requirement as to the shape, but in claim 2, the cup is going to be conical. So the issue is whether or not there's written description support for claim 1, which doesn't specify that it's conical. And the answer again is no. The patent here describes the invention as trapezoidal or conical. But again, that's not the only reasoning that the Federal Circuit applied. So here there's actually a brief mention of other shapes, but that was in respect to the prior art. And it's where the specification includes the advantages of the conical shape compared to other shapes in the prior art. So here, where they're actually distinguishing it over other shapes, there's not going to be written description support for when you're improving over the prior art. And they attempted to use expert testimony here, but the expert relied on one disclosure that wasn't even relevant to the shape of the cups. And then the other one was the prior art section, which again, if you're saying your invention is different and better based on distinguishing that feature, that testimony is not going to help you. Okay, so Allergan, this is a recent case from last year. This is an ANDA case that most people actually know for its obviousness, obvious type double patenting decision, but the written description analysis is also quite interesting. So this involves pharmaceuticals for treating diarrhea, where the active ingredient is aloxadoline. And the issue related to written description was whether there was support for a pharmaceutical tablet that does not include a glidant. So here it's about written description for an element that's not actually required. So if you look at claim 1, where it includes optionally a glidant and or a lubricant. So what does it mean when a claim includes optional language? What does that mean for the written description requirement? The district court said that there wasn't any indication that the glidant was not required to practice the invention, and analogized to ICU Medical and said that there was not sufficient written description for a disclosure without a glidant. So here, the Federal Circuit reversed, finding that there was written description support. It's a pretty interesting opinion. I mean, it begins with a standard analysis, I would say, where they look at the claim language, which they say is commensurate with the specification, and they actually note that the claims themselves are much narrower than a lot of other cases where this wasn't a genus case and the claims themselves recited specific ingredients and specific amounts. But really, because it was optional, it did not need to be specifically described for 112. And likewise, it wouldn't have been necessary in an accused product for infringement as well. So here, so I'm including in this section. So again, the district court relied on ICU Medical, where the Federal Circuit actually explained how this was different from the ICU Medical case that we just discussed regarding the spikeless valves, where here, there was no particular function to the glidant, right? So as the court explained, the specification in ICU Medical attributed a particular function to the spike, piercing a seal inside the valve that could not be accomplished without a spike. But that is different than the situation here where the specification attributes no particular function or significance to the glidant. The very fact that a glidant is not necessarily present in every embodiment indicates that it's optional, regardless of whether the inventors expressly described it as optional. Okay, so one other thing to note is that they relied on expert testimony. Here, there's a nice discussion of when really it's appropriate to rely on expert testimony and how it can be helpful. And here, the Federal Circuit they didn't fault the district court for crediting the expert testimony, but they explained when it's actually appropriate. So here, the proper inquiry must be into the specification first and then guided by expert testimony. Basically, you need to actually have something in the specification, and then the expert can opine upon it and elaborate, but there has to be something in the specification first. Again, without some basis in the specification that the invention would be understood to require a glidant, expert testimony cannot be used to fill the gap. And you'll see this come up in a few other cases that we're about to discuss. But this just brings us back to the point earlier where there has to be something in the disclosure. The expert can't simply rely on the state of the art without having a disclosure to provide an opinion upon. So that brings us to the next section of gap filling versus interpreting the specification. Okay, so the first case is the Lockwood versus American Airlines case. And these claims are directed to automated interactive sales terminals that provide sales presentations to customers and allow customers to order goods and services. And the district court found that one of Lockwood's other patents had anticipated one of the patents in suit. So the issue was whether the patent in suit could claim priority to an earlier application and avoid anticipation. And there were at least two limitations that were in dispute. The first was whether there was support for a computer system connected to multiple vendors. And the second was whether there was support for a computer with video disc players or equivalent storage. And here the answer was that there was no written description for both limitations. Here they also tried to rely on expert testimony. But really, what the expert testimony amounted to was an obviousness analysis, where the expert didn't actually even attempt to say that it was that any of the limitations were expressly disclosed. Instead, the expert opined saying that the embodiment or the limitations were possible and that certain things could be modified using what was known in the art to arrive at the claimed invention, which there it's really just a straight obviousness analysis. So like the court articulated, it is not sufficient for purposes of the written description requirement of section 112 that the disclosure, when combined with the knowledge of the art, would lead one to speculate as to modifications that the inventor might have envisioned but failed to disclose, right? So the expert was really just providing an obviousness analysis and not interpreting or analyzing anything in the specification. Yeah, the court further elaborated on this point, saying, while the meaning of terms, phrases, or diagrams in a disclosure is to be explained or interpreted from the vantage point of one skilled in the art, all the limitations must appear in the specification. So again, the issue is whether or not the expert is actually elaborating on something in the disclosure or just gap filling. And here it was gap filling and performing an obviousness analysis. Okay, the next case is going to be Rivera versus the International Trade Commission. And this is going to be a fairly similar case where the patent here, though, is directed to the Keurig brewing system, so the coffee makers, where the patent mostly discusses how there are different types of single brew coffee makers and that each maker is only compatible with a certain type of coffee pod. And it distinguishes between the different types of pods or K-cups. And basically, it acknowledges that there's a need in the art for an assembly that can be adapted, where one coffee maker could make coffee using different types of pods. But the issue here was that's not what the claims were directed to. So that was the entire focus of the patent, was how to have these pod adapter assemblies. But here, as you see in claim 5, there's this receptacle configured to receive the brewing material. But there is nothing in the patent disclosure that indicates the possibility of a cartridge with an integrated filter. So really, the claims were more directed to actually a pod instead of the adapter assembly. And again, in this case, there wasn't really an argument that the claim was expressly disclosed. It was a few different arguments that a POSA would be able to rely on the state of the art, and would be able to, would rely on the state of the art to adapt some of the disclosures. So here it says, again, reiterating the knowledge of ordinary artisans may be used to inform what is actually in the specification, but not to teach limitations that are not in the specification, even if those limitations would be rendered obvious. So again, it's pretty similar to Lockwood, where it's just, if you have to adapt and make changes, then it's going to amount to a gap-filling obviousness case. Okay, the next case is the Centrac case, which I like because it discusses both Lockwood and Rivera, and really hits home this point where, so Centrac was an appeal from district court, which granted summary judgment of no written description. The patents were directed to real-time location detection services that allow you to identify location of portable devices. And here the issue was whether there was written description for ultrasonic components. So if you see in claim 1, ultrasonic components are throughout claim 1. And the issue was whether or not there was written description for those claims, for that component. So the reason why it was an issue is because most of the specification focused on infrared or RF components instead of ultrasonic. But the difference in this case, as opposed to the earlier cases, is that there were 2 sentences in the specification that discuss ultrasonic technology. So the issue here is whether or not those 2 sentences were sufficient, where the district court had said no and granted summary judgment of no written description, saying that because the methods or tools were fundamentally different and would require different implementations and solutions, that there wasn't written description, and including because it failed to address certain issues like propagation delays or interference. So Centrac on appeal argued that all of the information that was necessary to address those issues basically were just basic routine implementations of details that were known in the art. And because it was known in the art, it didn't need to be spelled out. Again, there was expert testimony as well, stating that the differences between the infrared and the ultrasound capabilities were incidental. So here, is there written description support for ultrasonic components? Yes, there was. So the Federal Circuit reversed, saying there was at least a material dispute, and sent it back. Because again, this was on appeal from summary judgment. So they at least reversed and sent it back. But again, here I like because they distinguish between Rivera and Lockwood, where they note here there is at least a disclosure of the ultrasonic embodiment. While albeit brief, it distinguishes this case from the others. So here the expert was opining upon the actual statements, and it wasn't completely absent from the specification. So the next case is a case from last year. And this is an appeal from a final written decision of an IPR. So this is the 3G licensing case, which discusses the same issue about gap filling and obviousness, and whether or not there was sufficient written description. So here there was a dispute as to whether the challenge patent was entitled to an earlier priority date based on an earlier application. The board found that there was not. The patent issue is directed to mobile communication system for controlling data transmission between a base station and a mobile station. And representative claim 34 shown here includes the increased availability bit limitation, which is really the wherein limitation. So wherein a bit is sent on a reverse packet data control channel to indicate whether the mobile station has enough power and data to increase its data transmission rate on a reverse packet data channel. Uh, so that's referring to the IAB, or increased availability bid. So they wanted to claim priority back to a 6839 application, which disclosed a reverse rate indicator, or RRI. And the issue is whether the RRI provided disclosure for the IAB. And again, the answer is no. So 3G tried to rely on another document to show the RRI in the 6839 application can function as an IAB. And the board rejected it for two separate reasons. First, there was expert testimony that a person of skill in the art would not recognize that the RRI could function as an AIB. But additionally, and referring back to the same document that 3G had attempted to rely on, it was found that the RRI could only function as an IAB if it was modified. So essentially, it would have been an obvious invention. So up next is another recent case. And this one is from the Novartis case, is from January of this year. So this is a bench trial where the court found the claims invalid for lack of written description. And the claims are directed to a pharmaceutical composition that contain an antagonist, valsartan, and a inhibitor, sacubitril, and they are together in combination. And the product at issue is the drug sold under the brand name Entresto that's used to treat heart failure. And Entresto is a combination of those two components, but it's in a specific complex. So while the claim states in combination, the drug itself has a specific form that's complex together. And the issue was whether to show possession of the full scope of the claim, did there need to be written description support for the specific complex? So here the district court said that was required and that the specification did not have adequate support. So this case is pretty interesting. One thing to note is that it wasn't actually disputed whether the specific complex was known in the art at the time. There was no dispute that it wasn't actually known. And the court relied on that for saying that the claims were enabled because it was unknown. So you wouldn't actually have to enable making the complex. However, they took kind of a contrary position when it came to written description, where they said because the complex was unknown, it would not have been possible for the specification to describe the complex. But here you have to remember that all of the claims are actually directed to the two components in combination, right? It doesn't actually specify the complex. So the Federal Circuit reversed, focusing on what the actual claim language was, which was the components in combination. As the court notes, the issue is not whether the patent describes the complexes. Instead, the issue on appeal is whether the 659 patent describes what's claimed, a pharmaceutical composition comprising valsartan and sacubitril administered in combination. So again, yeah, there wasn't any dispute as to whether or not the actual combination was known in the art at that point. So while the complex clearly wasn't, and there wasn't a dispute about that, there also wasn't a dispute about the actual combination being described in the specification. And here, even the other party's expert conceded that it was adequately described in the specification. And what the court noted here was basically that the district court had conflated the issues of patentability and infringement. So it ended up reversing and finding that there was written description. So basically, you just need written description for what's actually claimed, and it doesn't have to cover a specific product. Okay, up next are open-ended claims. We're going to discuss three cases the Anderson, FS.com, and Regeneron. The first case, well, first we can discuss the test. So what do I mean by open-ended claims? I mean that there's no upper bound stated. So generally there will be some language in the claim referring to a minimum amount, or it'll say at least, or it'll specify some lower limit, but no upper limit is defined. In this case, the Federal Circuit has articulated a two-part test to apply to these open-ended claims. First one is whether or not there's an inherent limit known in the art. Would a skilled artisan be able to identify at the time what the inherent limit was? Second, does the specification describe or enable that limit? I'll note that some of these cases are going to be enablement because it's essentially the same test, and the analysis for some of these cases is kind of conflated, but it's the same rules that generally apply. So the first case is the Anderson case, and this is contains a patent directed to composite materials made from a mixture of polymer and wood fiber. The claim language is directed to a polymer composite structure and includes that Young's modulus of greater than 500,000. So it has the lower limit, right, is 500,000, but no upper limit is stated. So how do you know if it's described? So here there was inventor testimony saying that they weren't able to complete experiments of value greater than 1.2 million. So Fiber argued that without an upper limit, the patents were covering more than they could enable, because anything over 1.2 million was not enabled and not actually invented, and therefore invalid. The jury disagreed and found that they weren't invalid, and the Federal Circuit agreed with the district court. Here, there was inventor testimony that a person of skill in the art would be able to recognize what the upper limit was, which was somewhere in between the Young's modulus of wood and polymer used in the composition, and that based on that, based on the specification, was able to practice the invention to the upper limit. So the claims were described and enabled. So this brings us to the FS.com case, which is fairly recent. It's from 2023, and it's an enablement case. But again, it's still, I think, helpful for how to use and how to rely on expert testimony and how it can actually help you, and relying on the state of the art. So this was an appeal from the ITC, where the ITC said the claims were not invalid, and they are directed to high density fiber optics. Claim 1 includes that the fiber optic connection density is at least 98 fiber optic connections per use space. So again, 98 is a minimum, but there's no maximum stated. So are the claims enabled for values higher than 98? And the answer was yes. And again, this was mostly premised on expert testimony, where the expert testified that a POSA would understand that the relevant time period, the maximum density that was technologically feasible was 144 connections per use space. And that 144 connections was consistent with what was already disclosed in the specification. So the specification and the inherent limit known in the art matched. So the claims were enabled. And then there's this recent Regeneron case from earlier this year, where again, it's another open-ended claim case. So this is a biologics case related to a drug to treat macular degeneration. And Mylan wanted its biosimilar on the market. Regeneron filed for a preliminary injunction, which was granted because there was no substantial question of invalidity. So here in the claims recite, there's a formulation that includes at least 98% of a VEGF antagonist, a protein in its native form, and it needs to remain in the native form for at least 2 months. So again, 98% was the minimum value, but was 100% required because the claims were silent. So that's what Mylan argued. They argued that 100% stability after 2 months was needed, and that was not described in the specification because the highest amount was 99.3%. And here, again, the court relying on expert testimony found that the upper limit was described because there was expert testimony saying that proteins were not usually purified to 100%. So after 2 months, if you're not starting out with 100%, you're still not going to have 100%. And they found that around 99% would have been the upper limit, which was described in the specification. So this was just another instance of an expert being used to, inform the court on what an actual inherent limit was for an open-ended claim. Okay, up next are genus claims. So genus claims generally come up, or at least more recently, have been coming up in terms of enablement cases as opposed to written description, but we are going to touch on two fairly recent cases. The first is Juno, which is 4 years old, but it's still somewhat recent and definitely still relevant. So in Juno had sued Kite. The jury found in favor of Juno. The court denied JMOL on invalidity, and then Kite appealed. So this case is what I would say is a kind of a standard typical antibody case where the claims are defined by a functional element. Here you have the binding element that specifically interacts. And the issue was there written description support for the entire genus? First, we can go into how it's evaluated for genus claims. So when it comes to genus claims, there's a number of factors that the courts are going to evaluate, including the state of the art, predictability in the art, and the disclosure itself. So it's basically akin to the wants analysis for enablement. And the sufficiency of the disclosure, there's two different tests. So you can either show a represented number of species falling within the scope of the genus or some common structural features that would allow one of skill in the art to recognize the other members of the genus. So here the Federal Circuit found they reversed, finding that there was insufficient written description for the claims in Juno. And the analysis focuses a lot on expert testimony. They found it was too general. So to start with, there were only two actual examples of the single chain variants in the specification. And the testimony basically amounted to statements saying that they just do the same thing, they bind the same antigen. There wasn't real discussion of like common characteristics or anything where you could envision the rest of the genus. Really, it was just they do the same thing, which isn't going to be sufficient when it comes to written description for a genus. There have to be some sort of common characteristics, which were lacking from the expert's testimony. Okay, so that brings us to a more recent case regarding a genus. This is In re Zencor. This is from earlier 2025. And this is an appeal from a pending application from the board. So this was not an issued patent yet. And there are a handful of issues in this case, but I'm just going to focus on the issues directed to Claim 8. So Claim 8 is a Jepson claim. So it's directed to an improvement. And there were two issues involved in Claim 8. So the first one is whether there is actually a written description requirement for the preamble. So for the Jepson case, the preamble is going to be kind of what's already known in the art, and the rest of the claim is what the improvement is for. So first it was argued that no written description was required because the claims are directed to the improvement. So the improvement's the only thing actually requiring written description. The board had disagreed. They'd said the preamble is part of the invention, so it needs to additionally have written description support. And then they found that there wasn't sufficient written description, including because this was another antibody case, so there were not enough representative species. The Federal Circuit agreed. So Federal Circuit agreed, saying both that the Jepson claims do require written description for the preamble, where they emphasize that you really can't separate the preamble from the improvement. So the invention is not only the claimed improvement, but the claimed improvement as applied to the prior art. So the inventor has to show, has to provide written description to show possession of the claimed improvement to what was known in the prior art. And then because if you're arguing that part of this was known in the art, you actually do have to just show that what was well known in the art was in fact well known in the prior art. So here the antibodies they found were not sufficiently known in the art, and they found that the expert testimony was again too conclusory. They found that the expert testimony wasn't even credible. So there was not sufficient written description here. So even though the claim was really an improvement for something that was supposedly known in the prior art, you still needed to show both description for the improvement, but the improvement as applied to the prior art. And here they didn't even show that, or they failed to show that the antibodies were known in the art, and the expert testimony did not help because it was just, again, too conclusory. Okay, so there are a few cases to watch. So these are two district court cases that are currently pending appeal to the Federal Circuit that I just wanted to flag. The first case is the Wyeth versus AstraZeneca case. This was a case in Delaware where Judge Kiley from the Northern District of Illinois is a visiting judge. Here, the jury found that the claims were not invalid, and Judge Kiley granted JMOL finding lack of enablement and written description for a unit dosage term. So here, the patents are directed to a method of treating non-small cell lung cancer, specifically for treating GE-resistant NSCLC. And the inventors here claim that the GE resistance can be overcome by using irreversible EGFR inhibitors that covalently bind to a specific amino acid at a specific location of EGFR. And claim 1 is shown here, and you'll see it's a method of treatment that includes administering daily to a patient a unit dosage of the EGFR. And unit dosage is the main term in dispute. And again, this case, the analyses for enablement and written description are kind of intertwined. So I'll end up referring to both of them, but relevant. So here, the first argument that Wyeth tried to make was that all that was required in showing written description was that, or enablement, was that the drug was able to actually kill cancer cells effectively. But the district court rejected that argument because of the limitation administering daily to the patient. So just the drug being capable of killing cancer isn't sufficient. And that was because in part because some of the dosages within the described range could exhibit toxicity to the patient. So the fact that the claims included that you needed to actually administer this to the patient, there wasn't going to be a range. So it said between 2 and 500 milligrams per day for a unit dosage. And there was nothing suggesting that the inventors knew which actual unit dosage was effective and which ones could be administered daily at high enough levels to be effective and also to not be toxic to the patient. So because there wasn't any guidance on that, the court reversed and had granted or overturned the jury and found lack of written description and enablement. So this case is on appeal at the Federal Circuit. The briefing was completed just last month. So I think it'd probably be argued maybe in 6 months or so. I don't know. And then one last case that I will mention is the Natera v. CareDx case. And this is also a Delaware case where the jury also found the claims were not invalid, but the court granted JMOL of invalidity based on lack of written description. So the issue was whether a complete invention was described, or would someone have to take components of different embodiments, and was there any guidance in the specification as to how to combine them? And here there was some expert testimony that provided in support of combining elements, but the court again found the expert testimony to be too conclusory. But it'll be interesting to see what happens on appeal. Normally, this issue comes up in the context of pharmaceuticals, where there's a handful of components and laundry list of options for each one, which is not the scenario here. So it'll be interesting to see what happens on appeal in the Natera case, the Federal Circuit. The opening briefs were just filed this past week, so there's going to be a long time before argument. And that is my overall update on Section 112.
Thank you so much, Kylie, for that thorough and very engaging update. I learned a lot, and I know our audience will as well. Thank you so much to the audience for joining us, and we look forward to seeing you on our next program.
Thank you so much.